Well, we are a little more than 24 hours away from Oklahoma's next execution being carried out. Bigler Stouffer on death row for the murder of Putnam City teacher Linda Reeves. Stouffer making a last-minute appeal to the courts to spare his life. Joining me now, Professor Tracy Pearl, a law professor at the University of Oklahoma. Professor Pearl, good morning to you.
Good morning. Thanks for having me.
And thanks for coming on and talking about this. A lot to talk about here. I want to start with Bigler Stouffer, though, facing that 11th hour appeal this morning. Where do you see this going?
Yeah, it's highly unusual for the U.S. Supreme Court to grant a last-minute stay of execution, exceedingly rare. So I don't see this going far. The 10th Circuit has already declined to stay Mr. Stouffer's execution, and he's making an argument that the Supreme Court has rejected prior to this in the Glossop versus Gross case in 2015. So I think the Supreme Court is highly unlikely to stay the execution.
So if that does happen and it is denied, is Stouffer and his team basically all out of options at that point?
Yeah, unfortunately, given that Governor Stitt denied clemency last week, so this Supreme Court petition is really his last opportunity.
And I want to talk about clemency here. So Julius Jones, Pardon and Parole Board, recommended clemency based on doubts over his guilt. You had Bigler Stouffer, and we just talked about him, recommending clemency because of concerns over the execution process. But then you have Donald Grant, denied clemency. Gilbert Postel denied clemency. Can you take us kind of inside the decision-making process for the board here, the Pardon and Parole Board, and just how they're determining this?
Yeah, that's actually a really difficult thing to do. There isn't a standardized clemency process across the United States, and clemency proceedings aren't subject to review. And so there can be a lot of variation in what clemency boards are looking at, and they can be really difficult proceedings to predict. What I can tell you is that clemency can be granted for all sorts of reasons. So the board might have concerns that an individual was wrongfully convicted, which I think we saw with Julius Jones last month. The board may have the belief that an individual has been reformed or has overcome the error of their ways. There may even be sort of changed societal sentiments about whether the crime for which the individual was convicted should actually still be a crime. But there can also be, other things that are very case-by-case specific, like concerns about the inmate's mental health or competency, or sometimes just the fact that somebody is very elderly at a certain point may carry a lot of weight with the clemency board. So these are very fact-specific inquiries, and like I said, they can be really difficult to predict.
And a lot of people are wondering, you had Bigler Stouffer, they granted clemency for him because of concerns over the execution process, but you had Postel and Grant, clemency denied for them. Why is there that difference there? If they had concerns over Stouffer, where were those concerns for the other two inmates?
Yeah, that's a great question. And that's really unclear to me at this point. There is a federal lawsuit pending that is challenging Oklahoma's lethal injection protocol. I don't know the extent to which that's sort of factoring into the board's decision, but I'm just as curious as you are.
Yeah, and I was going to touch on that here, that federal lawsuit on behalf of 26 inmates who say that Oklahoma's 3-drug legal injection process violates the Constitution. That trial coming up probably in the first couple of months of next year. Any thoughts on how that may turn out, where that may go?
Yeah, I'm really curious about this case. I'm following it fairly closely. What's interesting is that in 2015, Oklahoma's lethal injection protocol was challenged unsuccessfully in a U.S. Supreme Court case called Glossop versus Gross. There, Mr. Glossop argued that the drug cocktail that Oklahoma was using carried with it an unacceptable risk of severe pain. And he lost that lawsuit. The Supreme Court ruled that Glossop hadn't successfully identified a known and available alternative method of execution that would be better, and that the lower court hadn't erred when it found that Mr. Glossop hadn't really established that the protocol carried with it the risk of pain. And so, that case might suggest that the inmates might lose here. But what's interesting is that that case also provided a roadmap for people who wanted to challenge a lethal injection protocol in the future. And here we see the inmates following that roadmap. So here they have actually identified alternatives that they argue would be better than the existing protocol. So I'm curious to see where it goes. Again, these can be really difficult cases to predict, but what I will tell you is it's usually very difficult to win a death penalty appeal.
And with all that being considered, with that trial coming up here in the next few months, many folks are wondering, why not just pause all executions until this is resolved? Is that an option here? Is that something that the governor would have to do? Where would that power come from?
Yeah, absolutely. So a court could stay the executions, the governor could stay executions. We've seen this actually happen in other states. This is a really interesting and uncertain time for the death penalty in America because states are having a really difficult time acquiring lethal injection drugs. So we've seen other states sort of put a pause on executions. We've seen other governors and other courts, come forth and say, wait, we can't go forward with this until we're more confident about the sort of soundness of the protocol that we're using. So that could certainly happen here as well.
I thought this was fascinating. There's now a question in the wake of the McGirt decision whether the state can carry out executions on tribal land, the state penitentiary on the Choctaw Nation reservation. Do you see that becoming a point of conflict moving forward when it comes to the death penalty here in Oklahoma?
Yeah, I think the short answer here is no, because under existing precedent, tribes can't regulate non-Indian conduct on Indian land. But this is a really complicated question of Indian law, and there are some exceptions to the principle that I just stated. So theoretically, it might be possible, for example, for the Choctaw Nation to say to the state, we're not going to allow you to conduct executions here anymore, but that would create a major conflict between the tribe and the state, and it's really uncertain what would happen at that point.
Any final thoughts here before we let you go on just the future, the overall future of the death penalty here in Oklahoma? It seems like it's a big topic of discussion, a lot of courts, a lot of litigation getting involved here. Where do you see things going?
Yeah, like I said, I think this is a really uncertain moment for the death penalty, not only in Oklahoma, but across the country. We see support for the death penalty consistently declining over time. And interestingly, we've seen that among historically pro-death penalty groups like evangelical Christians and fiscal conservatives. We've seen support for the death penalty dropping among those groups in recent years. And so I think it's unclear, what this is going to look like going into the future. Lethal injection is really becoming difficult because states can no longer acquire the drugs. And so I think the big question is, are we going to continue to try to create these drug cocktails? Are states going to move to a new method of execution? Nitrogen hypoxia is one that's spoken about a lot. Might we see the return of something like firing squads? These are all sort of questions that have yet to be answered and I think are going to be really interesting to follow in the coming years.
All right, Professor Tracy Pearl, fantastic expertise and insight this morning. We appreciate your time. Thank you so much.
Thank you so much.